We are talking about the concept of family trust, and we saw that any individual or a family head can be a settlor of this particular trust, and a trust is formed wherein the movable and immovable assets of that particular family or that particular individual can be put in that particular trust, and the settlor appoint the trustees. The trustees can be either a settlor can be a trustee, the relatives can be trustees, or anybody else can be appointed as a trustee. Even a manager can be appointed for the purpose of management of these activities. And thereafter, there are beneficiaries, where the beneficiaries, the persons to whom the benefit is to be given by the settlor. Settlor desires to give a benefit to a particular person, then that particular person, he may be a relative or any third person also, can be a beneficiary of this particular trust. The main advantage of this particular arrangement is that during the lifetime of that particular settlor, he can manage, he can decide as to how the benefits will go to the beneficiaries, in what proportion it will go. Many times it is possible that one of the beneficiaries is not so competent to look after the business, is not so competent to be a partner or a director of that particular business, but some benefits are required to be given. Or for example, there is a special child to whom the benefits are to be given, but at the same time the benefits cannot be given directly to him because he is not in the position to take care of that. Therefore, the trustees can be appointed, where the trustees will take care of the special child. They will be holding the property in the fiduciary interest or fiduciary way, and thereafter whatever is the income derived from that particular property that can be given to the beneficiary for the purpose of his well-being. This way, when the trust is formed, the purpose of formation of this trust, what is required is that an instrument of trust has to be enacted or executed. The execution of this instrument of trust requires special efforts because the beneficiary's interest must be percolated in the proper manner. The testator's, the settler's interest must be percolated in the proper manner up to the beneficiary, and the beneficiary must be in the position to derive the benefits which under this particular arrangement they are going to get. Now the question is that whether the beneficiaries will only get the benefits from that, or they will become the owner of this particular property at any time. This particular trust, this type of a trust, is a revocable trust. It is unlike a public trust, public charitable trust or a public religious trust, which is an irrevocable trust. This trust is a revocable trust. So the settlor can decide that this trust will continue till the time the beneficiaries are minor, and suppose the beneficiaries are minor children, then it will continue till that it become major, and thereafter it will be revoked, and then the entire property will go to the beneficiaries. One. Or if the settlor has not decided that, the board of trustees can decide as to when the trust can be revoked and the property will go to the beneficiaries. Or again, the beneficiaries themselves also can decide and insist upon the board of trustees that now the trust needs to be revoked, we want our property, and that will be an ownership property. If the movable assets are to be transferred, there is very less stamp duty. We are going to see about the stamp duty part and the taxation part of this also. That we will see in the next lecture.